Welcome to meeting number 33 of the House of Commons and Standing Committee on Justice and Human Rights. Pursuant to Standing Order 108 sub 2 and adopted on September 22nd, the committee is meeting to begin its study of the subject matter of Bill C-28, an act to amend the criminal code, self-induced extreme intoxication. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to take a few moments for the benefits of the witness, make a few comments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, please click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function, and the clerk and I will manage to the speaking order as best we can, and we appreciate your patience and understanding in this regard. I'd also like to let you know that I will be using a few cue cards. I just, when you have 30 seconds left in your speaking time, I'll raise this book. It's just a yellow background for now, and then when your time is up, I'll use this red folder, and that indicates that your time is up. So without further ado, I'd like to welcome our first witness, the first hour, and that's our...
Monsieur le Président, avec votre permission.
Mr. Chair, with your permission, I would like to check something. I did not hear you mention, but were audio tests done with the witness who's in Zoom? Were the results satisfactory? Was there a sound test done?
Mr. Clark acknowledges yes, they were all tested, and they all have passed the sound test.
Merci, Monsieur le Président.
Thank you, Mr. Chair.
So, without further ado, I would ask our Minister of Justice, the Honourable David Lametti, to begin for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you for having invited me to this study of former Bill C-28, an act to amend the criminal code, self-induced extreme intoxication. I'm supported here today by lawyers of the department, Matthew Taylor, Chelsea Moore, and on the screen, Joanne Kleinberg. So thank you all for being here. As you know, this bill was adopted on June 23rd, 2022, less than 6 weeks after the decisions. Is it the Queen or the King? Well, Queen versus Brown are versus Sullivan and Chan, rendered by the Supreme Court of Canada. In these decisions, the Supreme Court concluded that the former version of Section 33.1 of the Criminal Code was unconstitutional because it removed the defense of extreme intoxication in all cases, whether the person acted negligently or made a mistake while consuming the intoxicant.
The defense of extreme intoxication as a full defense for violent crimes and allowed accused persons to escape liability even when they negligently consumed drugs or other intoxicants. The quick passage of this law reflected the desire of all parliamentarians to close the gap in the law left by those decisions. Following Bill C-28, the law now provides that those who are criminally negligent in their voluntary consumption of intoxicants can be held liable for the harm they cause to others while in a state of extreme intoxication. Former Bill C-28 was described by the Women's Legal and Education and Action Fund, LEAF, as a thoughtful, nuanced, and constitutional solution to the small but important gap left in the law by the Supreme Court decisions. The objectives of former Bill C-28 are the same as the previous version of Section 33.1 adopted in 1996. To protect victims of intoxicated violence by holding accountable those who negligently self-intoxicate and cause harm to others. The court in Brown recognized these objectives as legitimate and pressing and suggested two constitutionally viable pathways that Parliament could adopt to ensure liability in appropriate cases. We chose one of those approaches, which allows a conviction for the crime of violence, such as manslaughter or sexual assault. This approach will hold offenders accountable, as victims rightly expect, while also respecting the Charter. Under the new Section 33.1, the Crown may seek a conviction for violent crime by proving that the accused hurt someone while in a state of extreme intoxication resulting from their own criminally negligent consumption of intoxicants. The person would be held criminally liable if they were proved to have departed markedly from the standard of care expected of a reasonable person in those circumstances. A marked departure means that a person's conduct fell far below what a reasonable person would have done in those circumstances to avoid a foreseeable risk. In this case, the risk of a violent loss of control. Vous vous souviendrez qu'une intoxication est
You will recall that self-induced extreme intoxication is a rare mental state that is an automatic state where an accused has no control over their actions but is still able to act. Allow me to specify once again that this state is exceptionally rare and that intoxication, even high levels of intoxication, do not meet the definition of extreme intoxication. And I repeat, intoxication in and of itself never constitutes a defense for a crime such as sexual assault.
well, because it is critical for everyone to understand. Intoxication is never a defense to crimes like sexual assault. That was the case after the Supreme Court decisions. It remains the case today. Using extreme intoxication as a defense is very difficult. In order to succeed, the accused has to meet a higher evidentiary threshold that normally applies, first by convincing a judge on the balance of probabilities and with expert evidence that they were extremely intoxicated at the time of the violence. Drunkenness or intoxication in and of itself is not a defense. Extreme intoxication is a rare and extreme state, and the Supreme Court has made it clear that it is nearly impossible to end up in a state of extreme intoxication through the consumption of alcohol alone. Bill C-28 closed a narrow but important gap in the law to ensure that the use of this defense remains exceptionally rare. Some have suggested that the new provision will be hard to enforce, claiming it would be too much of a challenge for the Crown to prove that the risk of violence was foreseeable. I disagree. In my view, this new law is eminently enforceable. Parliament has sent a clear signal that anyone who voluntarily consumes intoxicants in circumstances by showing gross disregard for the safety of others will be held accountable if they go on to commit violence. I note specifically that the law only requires a risk of violent loss of control. Properly interpreted, this is a lower threshold than we find in other provisions of the Criminal Code, which require that a particular outcome be likely, such as under Section 215, where a person who is likely to cause permanent health injuries to another may be liable for failing to provide the necessaries of life. Crowns successfully proved that offense despite the higher likely standard. So I'm confident that they will be able to prove that there was a risk of violent loss of control as well. And keep in mind, the Crown does not need to prove any of this unless the accused has already met the very high bar of proving that they were in a state of extreme intoxication. And if the accused can't prove that, they will be guilty of the offense like anyone else. Les Canadiens raisonnables veulent connaître les risques.
Reasonable Canadians want to know the risks, even rare, that are linked to intoxicants that they might consume and the way they expect to consume them, and all reasonable Canadian is concerned by the safety of others when their acts present a risk.
Of misinformation following the Supreme Court decision, we knew it was important to act quickly. There was a lot of conversation that simple intoxication could be used as a defense for horrific crimes such as sexual assault. This unintentional misinformation and the sometime intentional alarmist reporting style comes with very serious consequences for women across the country, adding to the stigma that the survivors already faced when reporting gender-based violence. We acted quickly to ensure that this sort of narrative did not remain in the public realm, as it is important for all Canadians to feel safe. I'm pleased that all parliamentarians were able to come together and act swiftly to prevent the misinformation from taking deep roots. I will closely be following your study on this important issue, and I look forward to reading your final report. In the meantime, we'll continue to work closely with our federal, provincial, and territorial partners to ensure the effective implementation of the legislation. Je vous remercie. Thank you.
Thank you, Minister. Now we'll go to our first round of questions, beginning with Mr. Moore for 6 minutes.
Thank you, Chair, and thank you, Minister, for appearing today on this important study. People may wonder why we're having this study today, and it was because of a Supreme Court decision, the Brown ruling, that frankly put Canadians, particularly women, at risk. I know MP Vecchio and MP Brock, who serves on this committee, MP Caputo, and myself wrote a letter to you urging that you act quickly, and also that offering any assistance we could be to close what it was a very, I feel, serious condition in our criminal code, and a serious gap created by the decision. So there's going to be a lot of questions today about the bill. I want to ask a broader question, though. You know, your government does respond to things when they see fit. For example, when there was a vacancy for the Ombudsman for prisoners, it was filled the next day. When there was a vacancy for the Ombudsman of victims of crime, it took a full year to fill that important position. I would have liked to have had the benefit of hearing from an Ombudsman of victims of crime in the process around Bill C-5, around this, and other criminal justice legislation. We've just completed a study hearing witness testimony on victims of crime. And one of the most high-profile cases in Canada in recent memory, Charlene Bosma, whose husband Tim was killed, and it captured the attention of all Canadians. The individual that took his life was convicted also of killing his own father and his ex-girlfriend. Thanks to legislation that was put in place to allow for consecutive periods of parole ineligibility, he received a parole ineligibility period of 75 years. The Supreme Court decision in Bissonnette has resulted in a scenario where this individual will be eligible for parole after 25 years, and the clock started ticking on that, I think, almost a decade ago. So when Charlene Bosma was here, she said the one bit of light that she hung on to in the whole situation was knowing that thanks to what she did and the Crown Prosecutor and other witnesses, that her daughter would never have to go to parole hearings. We heard over and over how parole hearings re-victimize victims and their families. So my question, Minister, is you responded and we cooperated with you to get swift passage of C-28. This hearing is part of that, to see if, is there ways it can be improved. But will you and will your government respond to the Supreme Court decision in Bissonnette?
Thank you, Mr. Moore, for that question. Obviously, whether it's survivors of the mosque shooting in Quebec City, or the Bosma family, or others who have been victims of these horrific acts, our sympathy goes out to them, and we do our best to make the system we do our best to make the system work as quickly as possible. We diligently try to fill the position of the ombudsperson for victims of crime. Sometimes there are things that turn out to be out of your control in the way those processes work at an individual level. I won't go any further into detail, but we did our best from the beginning to fill that position. Now we have, and I think everyone agrees that the person that we've picked is very good. The difference between the Bissonnette decision and this is that in this case is the Supreme Court gave us a couple of paths to move forward. Bissonnette decision again doesn't change the actual sentence that the convicted killer got in that case. It only adds eligibility for parole. And I appreciate that's important, but eligibility for parole does not mean the person will get parole. We did our best to defend that case as part of the discretion that a judge has to impose that kind of sentence. That was the argument that the Attorney General of Canada made in that case in front of the Supreme Court. The court didn't accept it, and by a 9-0 decision. So it is. I'm open to suggestions, but it doesn't have a path or two paths in the case that we're looking at today with Brown and Sullivan. It doesn't have an easy or clear path, and the decision itself of the Supreme Court was pretty clear in terms of the interpretation of the Constitution. But I would just underline that eligibility for parole is not parole. It doesn't guarantee parole, and the sentence as it exists still stands.
Thank you, Minister. And I guess what I would urge and what we're urging is that the same minds that came together to respond to the decision in Brown, that looked at the possible choices, and there were choices that were made, and we're going to have time to discuss the pros and cons of the different options in Brown, that those same minds turned to the Bissonnette ruling. We've heard testimony from victims, multiple victims now, and their families who said the parole process in and of itself is a re-victimization, knowing that their children have to take part in this. In my own constituency, I have someone who was just recently at large, paroled for killing one of my constituents' daughter when she was 16 years old. Nobody even knew where he was, and now we understand he's up for parole again, even though he was unlawfully at large. So the parole process in and of itself is a re-victimization, and we need to turn those same minds into a response to the Bissonnette ruling, and I would certainly urge that.
Thank you, Mr. Moore. We're unfortunately out of time.
Thank you, Chair.
We'll now go to Ms. Diab for 6 minutes.
Thank you very much, Mr. Chair, and merci beaucoup, Monsieur le Ministre.
Thank you, Mr. Minister. We very much appreciate your testimony here to clarify Bill C-28.
Questions, because I find there's a lot of confusion and misunderstanding, and a lot of it, when you talk about the legal terminology and everything else, I can see why normal people really get confused by a lot of this stuff. Last meeting we had, I very much appreciated the fact that Mad Canada was actually present, because in their testimony, and it was very clear and concise testimony, that the legislation would not impact them whatsoever. And I think that is very, very, very important for Canadians to understand. And your testimony today that it will never apply to crimes of sexual assault. That is the kind of testimony, and that is the kind of facts and that we need Canadians to really understand. So I'm going to ask you, can you again clarify for Canadians in normal English and French, whatever language that is non-technical, I guess is what I'm saying. I used to belong to Access to Justice Committee in Nova Scotia. And one of the first meetings is, maybe because English and French were never my first languages, I very much appreciated understanding things very simple, clear language. What is extreme intoxication? What is self-induced intoxication? What are we talking about here, Minister?
Thank you. Thank you, Ms. Diab, for the question. So self-induced it means you took the intoxicant yourself, whether it's alcohol, whether it's drugs, or whatever. So self-induced just refers to how you took them, and you took them of your own accord, and so hence that puts a bracket around what we're doing. The extreme intoxication has been interpreted by the courts as something akin to a state of automatism. So your body is functioning, but you're not in control of it, I think is the easiest way to put it. Your arms and limbs are moving, and in rare cases you are capable of doing extreme acts, but you're not controlling yourself anymore. It is a rare set of circumstances. But legally, it has been carved out of a number of different things, and so there is a carve-out here. What we are doing is recognizing that the manner in which you entered that state of automatism, even though you did it yourself, matters. And so in most cases, when it was reasonable for you to predict that there might be a loss of control, a loss of self-control, or that there might be a violent outcome, you will still be held responsible for whatever you did. So if it was sexual assault, you will still be responsible for sexual assault. If it was manslaughter, you'll still be responsible for manslaughter. The only rare exception is if there was something that meant you couldn't have known, or you shouldn't have known, or you ought not to have known, according to an objective, reasonable standard. So if you got prescription pills for the first time and it couldn't have been predicted that you would have had, nobody would have known, you couldn't have known, you couldn't possibly have known that you would have had this outcome, maybe you've got a chance here if that provoked that kind of state of automatism. But again, you've got to reach that state, and you have to prove that state, and then it's up to the Crown to show that you couldn't, that you could have predicted, or you should have known, or otherwise ought to have known.
Thank you, Minister. With my time left, I'm going to have 2 questions, and then feel free with my time left. How will Bill C-28 make Canadians and victims be safer because of crime? And how commonly is this self-induced extreme intoxication? How commonly is it used as a defense by alleged perpetrators based on what you've been told?
It is rarely used as a defense, and even more rarely invoked successfully. No reported cases since we've amended, and since the earlier the Supreme Court decision, it was only rarely used and very, very infrequently successful. It makes women safer, it makes men safer from acts that are perpetrated while in a state of self-induced intoxication, in the sense that it holds more people criminally responsible and only carves out those who had no way of knowing that this could have or should have happened. And it helps us, in a larger sense, deliver the message that intoxication is not a defense. You are responsible for what you do when you get intoxicated. And I think that is as important as the Criminal Code amendment itself. It is sending out that message to everybody to counter that false narrative that somehow you can get off if you were drunk or if you were high, and it is simply not the case.
Okay, thank you so much. Much appreciated.
Thank you, Ms. Diab. Next, we'll go to Monsieur Fortin for 6 minutes.
Merci, monsieur.
Thank you. And hello, Mr. Minister. I'm very pleased to see you here today. At the Bloc, we applaud this decision. We had to close this gap. I think it's important. To me, this text seems very good, but I do have a few questions. Since the beginning, I have a little bit of issue with self-induced extreme intoxication. Is there not then a possibility, let's say if somebody would say, well, I do meet the criteria, but I was not voluntarily intoxicated. For example, someone put something in my drink, or someone added a more powerful substance in the joint that I thought I was smoking pot, but it was something else. Did you look at this aspect of the issue? Extreme intoxication, if an accused might say that this is involuntary but was not self-induced. Thank you, Mr. Fortin, for this question. Obviously, we're considering self-induced intoxication here. So if it's true that someone else was the cause of the intoxication, it could be a defense, but it would depend. It would depend on the facts of the case. So this is a separate issue. If, in the circumstances, a person should have known that there was a risk. Well, we're not talking about how we're going to roll a joint here, but even if we look at the source, it would be very difficult for the accused to establish innocence. The context will determine what happens. Case law does have standards to reinforce the message that self-induced intoxication is not a defense, and exceptions are extremely rare. Thank you. Thank you. Now, in the case, you have a definition here of extreme intoxication in Section 4. A person is able to control themselves or be conscious of their acts. It seems a little bit vague. In your opinion, is this definition sufficient so that the courts will be able to act in a consensual or decide in a consensual manner? Or would it have been better to define extreme? Thank you. It's a very good question. This is a known definition. So we reused the definition in the previous act. It's also a definition that has been qualified by case law. It's separate to an automatic state where someone does not master their acts consciously. So with the legal interpretations through case law, it's much easier to understand. And this is a standard that is known. It is known in the courts. It's a workable standard. So it is a workable standard. Thank you. I'm going to change subjects. We've already received witness testimony from organizations last week on C-28, and a comment that was a little bit surprising and that seemed to come back. People were talking about consultations, and some individuals did not feel that they had been consulted or that they were not sufficiently consulted. Could you speak to the consultations made by your department before tabling C-28? Who was consulted, on what aspects of the bill, and what were the comments made by organizations or individuals that were consulted? Thank you. Yes, we did consultation. We also consulted beforehand. And I can share this with you. I believe we've already done it, but I can share, once again, the list: Women's Shelters of Canada, Luke's Place, Pathway Group, Ontario Network of Victim Service Providers, Fédération des Maisons d'Hébergement pour Femmes, Ferrocon, Canadian Women's Foundation, LEAF, Robin Parker, National Association of Friendship Centers, Native Women's Associations, Action Now Atlantic, Students for Consent Culture, Kent Roach, Janine Benedict, Francis Chapman, Joy Ferguson, Michael Plax, Hugues Parent, Canadian Association of Black Lawyers, Criminal Lawyers Association, Defense Council, Association des Avocats de la Défense du Québec, Tony Paisana, Jody Burks, Women's Law Association, Women's Law Association of Ontario, National Association and the Law. So we did consult. And the majority have supported us, formally or informally. They've supported our approach. Do you have were there specific concerns raised by these organizations? I can tell you that the National Association of Women in Law did not agree. They wanted something that was more similar to the former act.
Monsieur Fortin. Next to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and thank you to the Minister for being with us today. And
I just want to emphasize again, I think the context that we were working with here was the creation of a gap in law which was maybe smaller than the public perceived, and the degree of cooperation in acting quickly in Parliament. Sometimes, as an institution, we have a bad rep for not being able to get things done. And in this case, when we talk about the consultations, that's an impressive list. We know that they weren't as fulsome as they might have been because of the speed that was necessary. Otherwise, we'd be sitting here now having consultations, having these hearings, with the gap having been in existence for months on end. So I appreciate the leadership that you showed in approaching all of us to get this done. The Supreme Court essentially gave Parliament two choices, and I'd like you to talk just for a minute about those two choices. In kind of common language, the court said, well, you could either create a new offense or you can fix the existing section. Can you talk a bit about why the choice was made to fix 33(1) rather than create a new offense?
Thank you. Thank you for the question. Thank you for thanks to all of you for the support. There was only one article, so there was an advantage there in terms of consultations that made them more efficient. And it was a known problem. There had been legal scholars who felt that this provision was unconstitutional from the Davio decision, at the time of the Davio decision. So the court gave us two options: create a new law that basically framed this kind of situation, or take the old law and address the situation that they were worried about, which is the person who innocently goes into that state without any ability to have known that this might happen, right, or shouldn't have on an objective standard. We felt that second option was easier because it contained known standards, first of all, and for judges, for Crown prosecutors, for defense attorneys, it had less potential unforeseen consequences. When you create a new standard, create a new law, there's going to be periods of interpretation. What's the scope? How far will this go? What does this include? And in part, it was that. And the other part is victims themselves said, the person sexually assaulted me. I want the person to be charged with sexual assault. I don't want them to be charged with some form of criminal negligence. It doesn't carry the same stigma. And I think that was probably determinative.
Because of scheduling, we had an unusual circumstance that we heard some of the witnesses as part of this consultation before we heard from you today, right, Mr. Minister. So maybe this is something that doesn't usually happen. It might be a little bit unfair, but we heard from the Native Women's Association of Canada, Ms. McBride and Mr. Bond, quite eloquent testimony that while they felt that this was a good solution, that it was not a sufficient action from government, in the context of the overall number of Indigenous women in Canada who faced violence. And what they were saying was that they hoped that the fact that this had come up at the Supreme Court level might lead to a broader consideration, a broader strategy for dealing with the root causes of violence against Indigenous women in this country. Do you have any response to that testimony, which was quite moving?
I would say I don't disagree with any of that. I do think we need a broader response across a variety of different levels to address the social determinants of crime, the factors that lead to it, and better support for victims as well, particularly in more remote communities where it's sort of doubled in terms of impact. If I had the solution, I would have done it a long time ago. I am working with colleagues, with all of you, to find other solutions, and I certainly agree with the tenor of those remarks.
One of the things that Ms. McBride said quite clearly is that there's a real lack of capacity in most First Nations to deal with some of these root causes of violence, and that capacity building funding for those community level organizations is what's really needed. And I know that not necessarily come from your ministry, but it seemed quite insightful in that she was emphasizing that each First Nation might have a different way of dealing with those causes of violence, but without the capacity building, they weren't able to address it.
Agree again. Agree with the observation and the sentiment. I do my best to get funding for things like community justice centres. I've had some now success with that, funding community justice centres, particularly in the Indigenous context, but also in the context of children, the children's advocacy centres and that sort of thing, which I think I've succeeded at getting funding for. And I do try to convince my colleagues that we need more funding across the board in a variety of different ground-up organizations, because I think the observation is right, which is that's the only way that we will be able to effectively combat this.
Maybe 30 seconds, just quickly. Since we've passed this, have you heard from organizations about the sufficiency of this action? In other words, from those who were consulted originally, have you heard back from them about whether they think this is enough, the solution that we suggested?
I think we're all watching carefully. I think the defense was invoked once without success, and certainly has not been invoked successfully. And obviously, we're still in dialogue. I think the groups that initially supported it are still supportive, and the groups that initially had reservations still have reservations, and you're going to hear that in your committee. But certainly, we're watching carefully and monitoring our dialogues carefully.
Thank you.
Thank you. Thank you, Mr. Garrison. Next, we have Ms. Vecchio for 5 minutes.
Thank you, Mr. Speaker, or Mr. President. I am so glad to be here to talk about Bill C-28. As the Minister knows, this is something that, working as the Shadow Minister for Women and Gender Equality and also being the Chair of the Status of Women, we talk about these things a lot. And we know that intimate partner violence, we know that the statistics are showing that in many of these cases, if we're looking at the violence, it's men versus women. And then if we're looking at extreme intoxication or with alcohol or drugs, we once again know that those statistics are very, very high. Minister, you spoke about the members such as LEAF and organizations that were receptive of this, but we also know that there were groups that were not. I have a list of at least 20 here that were not. So I think the one thing I want to just say, let's make sure we listen to them all. I know we have this preconceived notion, and to anybody that's out there, the question is, why are we studying a bill after? And just as Mr. Moore has said this, it's important that we do this, but I'm really hoping that we're taking these lessons as learned, and actually if there needs to be changes, that we're actually going to do them, because the women's voices need to be heard. So when I'm looking at this, LEAF versus, I'm kind of looking at LEAF versus the National Association of Women in Law, because we're looking at two similar organizations, one that's very supportive and one that's not. Can you describe to me the conversation that you've had with the National Association of Women in Law and things that they would like to see you change?
Well, I know that they're concerned that there's no preamble to this piece of legislation. Our view is that the preamble remained the same, and the court found in its decisions in Brown that there was a legitimate legislative purpose. So we didn't feel we needed to change the preamble. We feel the preamble still applies, and so I guess we respectfully disagree, but we certainly understand.
Minister,
Yeah.
have you spoken to him personally? Have you spoken to some of the and during these consultations? Have you spoken?
This
to him?
happened so quickly that we fanned out across my team, but my team did speak to members of NOL.
If we're talking about the consultations, how many consultations would you have participated in?
I participated in a few, but very few actually, given the timing of it. It was my team, my political team, reaching out.
Fair
and
enough.
My team does extensively. We do this extensively across the board on a number of pieces of legislation, and given the timing of it, but given the urgency of it, I received the letter from you, thankfully, and from Mr. Moore.
And I think you and I both agree that we need to make sure that we do close these gaps when it comes to this, because we know right now approximately 6%, if I'm looking at the statistics, this is something that's very, very concerning, because we talk about extreme intoxication, and according to the testimony that we received last week from Jennifer Dunn at the London Abused Women's Centre, and if anyone knows me, they know that is the one I usually refer to. We know from Statistics Canada that only 6% of sexual assault cases are reported to police, and of those 6%, only 1 in 5 results in a trial. So I think these are some of the concerns that we see, as we already know we've got a problem when we come into the court systems. And when we see that people are not reporting, what are you and your department doing to ensure that it's more welcoming, it's better for when victims of crime come forward, that they are going to be supported by the law itself?
Well, we've made a number of changes since coming into power in 2015 to sexual assault definitions, for example, in the criminal code, to prevent re-victimization, to channel the kinds of examination and cross-examination that are legitimate. Again, with a view to helping protect victims when they come forward.
Fair
when they
enough,
do come
Minister.
forward. No,
Fair
these are
enough.
critical
Yeah,
because
no,
this
absolutely.
is
Excuse
the treatment.
me.
The
Hi.
treatment of
I'm gonna-
victims in the. Let me just finish the answer.
No,
the
it's
treatment
okay,
of victims.
sir. It
You've
is
asked
my
me-
time as the chair of the
No,
status
but
women. I
you've-
know my roles.
you've asked me
so,
the
sir, I'm
question.
just going to move on to the next question.
But
if
you've
you don't
asked me the
mind.
question. I do
I'm
want
just-
to answer it.
I'm going to just move on to the
Okay.
next question because my time is very, very slight. So I'm looking at training of judges, and I know we have in the room today the sponsor of Bill C-233. I know that you yourself have put through something. What are we seeing on the uptake of judges? Because I think one of my biggest concerns is when people come into the system, they do not feel that they're going to get the adequacy of what they need. Victims aren't coming forward because they do not trust the system. So where are we at when it comes to judges training?
Well, we now have passed a bill that requires any new federally appointed judge to agree to take on training that includes and primarily focuses on sexual assault as part of their application. So they have to do it in order to be named a judge. So they get it immediately afterwards. That's going well. The National Judicial Institute has taken that on.
Can I ask
And
a question? How long, just a quick question on that. So they have to take it. How long is that course? And is it something that continuously gets built on? For instance, you know, social media wasn't here 20 years ago, and heck, has it ever changed our lives now? So how frequently do they have to take it? Once they've taken it the first time, do they need to take it again? Do they need to continue with their skills and improvements on sexual assault and things of that sort?
Well,
Very quickly.
we put that bill into place precisely to get people to agree to do it before they became a judge, because once they become a judge, the principle of judicial independence says we can't force them. Chief justices do their best to ask their judges to be retrained, and this is having a positive impact because it's sent out a message that this is important. And finally, it's creating, I think, an impetus for provincial court judges who deal with most of the criminal cases in Canada to do the same thing. So there's a real set of standards that are being set. And finally, I would say the National Judicial Institute is world-renowned for judicial training. They train judges from around the world, including Canada, and they continually update their offerings.
Thank you. Thank you, Ms. Vecchio. Now we'll go to Mr. Naqvi for 5 minutes.
Good morning, Attorney. Thank you for being here. I know there were some conversations by my colleagues, questions asked around stakeholders that have been consulted on this bill. Would you be able to table a list of the stakeholders for the benefit of this committee so that we have it?
Certainly can.
That would be great. Thank you very much. I was listening to your comments, especially around misinformation when the Supreme Court decision came about. Things that I, through legal circles, were hearing were of real concern in the immediate aftermath of the decision. Can you share with us what were you hearing and from people that you collaborate with and consult with around the impact and the message that that particular decision from Supreme Court was having in the community writ large?
Thank you for that question. In fact, it was probably one of the most important factors that pushed us to move quickly. There was a great deal of misinformation on social media in particular, and we all saw bits of it without seeing all of it, that all of a sudden, if you were intoxicated, this was a get-out-of-jail-free card, that this was a pass. And it was an explosion of misinformation, and we needed to correct it quickly. Even though this was only a rare case, even though that wasn't true, it didn't matter. People felt it was. So by breaching this admittedly small gap, we could reinforce the larger message, which is, if you get drunk, you will be responsible. You'll be held responsible. And that's a critically important message that people needed to hear. I wish we didn't have to do that, quite frankly. I wish that there wasn't that level of misinformation out there. Whether it's erroneous or deliberate is inconsequential. It is there. And so we needed to fight. We still need to fight that message constantly. We all have a responsibility to do that. Closing this gap helped us to do that, and closing it quickly helped us to reinforce that even more.
Thank you. And I think the message is an important one and a strong one in terms of preventing gender-based violence, and the manner in which the Parliament acted in unison in such an expedient manner, all political parties combining forces together. I think speaks volumes of the collective motivation on our behalf, on behalf of our constituents and all Canadians. I'm also quite interested in the process by which you determined the recourse to take. There was some call for you to invoke the notwithstanding clause. You chose not to do so, and I appreciate that. But we're quite surgical and methodical in terms of the solution you came with. Can you walk us through the kind of a deliberation in matters like these of constitutional nature that you and your department goes through to make a determination as to how to remedy a law based on the decision that's offered to us by the Supreme Court of Canada?
Well, thank you. Thank you for that question, an interesting process question. First of all, I'm surrounded by a great group of lawyers, both in the Department of Justice and on my political team, and so we're generally quite attuned to this. In this kind of case, we were given a roadmap by the Supreme Court of Canada. The notwithstanding clause is possible. It is part of the Constitution. I believe it's meant to be used only as a last resort. That's what the framers wanted in 1982. And only when there weren't other options, because with the notwithstanding clause, you're infringing on people's rights. And so here they gave us two ways to do it without infringing on people's rights, and we took one of them. This particular clause also had the advantage of having been studied since the Davio case in 1993. So there was a body of existing opinion out there that we knew of people who had already felt that it was in particular unconstitutional. So we had a head start. Once that happens, the usual processes within the Justice Department and then the consultation process allowed us to come up with something using the Supreme Court roadmap fairly expeditiously.
I very much appreciate that, because I appreciate the thoughtfulness that must go into reviewing and then complying with Supreme Court decisions, and the kind of surgical approach that you took in this particular instance, as opposed to taking a sort of a broad brush way of remedying the situation. So I think it's a reason I ask, because that thought process is missed in terms of broader public's understanding of the kind of delicate steps the government, especially Department of Justice, needs to take. So I sincerely appreciate that. In my limited,
Mr. Naqvi, your time is up. I will next go to Ms. Sear-Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you. Mr. Minister, in 2 minutes I don't have a lot of time, but I'd like to hear you speak to an issue that might be a little bit broader than Bill C-28. In cases where we study some aspects of criminal legislation, the main hurdle is that oftentimes the victims have the impression that they were not consulted, that they were not taken into account in the legal process. So when I look at C-28 on self-induced extreme intoxication, I imagine the criticism will come from victims, and probably rightly so. They will say, well, I was raped, I was harmed, or regardless, by a person, whether it be a man or a woman. This person says that they were extremely intoxicated, involuntarily or voluntarily, but all of this aspect might lead to criticism from victims. Have you examined this? That the victims of these crimes, should they not be taken into account in the legal process? For example, participate in the trial if they want to, participate in the decision. I know that the administration of justice is a provincial jurisdiction, but with regards to legislation, would it not be that some aspects could be covered by the federal government, for example, in the criminal code, to make sure that victims would be taken into account more when we're talking about crimes, especially violent crimes? Thank you for the question. I think that This is exactly what we're doing. We are laying out the maximum. We're doing everything we can here in order that someone be found guilty. It's very hard to meet the standard. People are trying here to meet a standard that is extremely difficult. It would be very difficult for the accused to meet this standard for extreme intoxication and to minimize the opportunities of having this as a defense. So what we're doing is that we're giving the maximum amount to the victims so that someone might be able to be found guilty within the standards. Shouldn't victims... Sorry, thank you.
Mr. Garrison for 2.5 minutes.
Thank you, Mr. Chair. Mr. Minister, I'm going to actually ask you a question I didn't intend to ask you, but my colleagues have broadened the discussion here. We've just had a report. This is the 7th consecutive year of an increase in intimate partner, 7th consecutive year of an increase in intimate partner violence, and an increase in the severity of the violence. And in 2019, for instance, we saw 77 homicide victims in intimate partner cases, 2020, 84, and 2021, 90 of those cases. So this committee has twice recommended to the government a package of measures to deal with intimate partner violence. And one of the things suggested was making coercive controlling behavior a criminal offense. Do you think making coercive controlling behavior in intimate partner relationships would be a useful tool for combating intimate partner violence?
Thank you for that question. And first of all, generally on intimate partner violence, I share the broad concerns here. And we've tried a number of measures. We're open to a number of measures. And I am open to creating an offense of coercive control. We need to look at other jurisdictions. I know that's what the committee was doing, and that's what we need to do. But I'm certainly open to that, and I think that it could be a very, very useful addition to this. To the tools that we have.
And in terms of, I guess I hate whole of government, but whole of government response across the country, one of the problems seems to be the differing ways provinces provide services and supports to victims of intimate partner violence. Has there been any consideration given to some kind of task force which would look at best practices and minimum standards for jurisdictions across the country in responding?
I would certainly be open to that. I've just come back from a federal, provincial, territorial First Ministers meeting, and they did actually congratulate us on this piece of legislation, so all of us collectively for having worked together, so thank you. But we did also discuss as one of the topics, how do we support, Quebec, for example, is trying specialized courts, which seems to me to be a good idea. But much of this, the administration of justice, is in provincial and territorial hands. So we're there as a willing partner. But I would be open to ideas to making sure that we have, the best practices recognized across the country and those standards met.
Thank you, Mr. Minister.
Thank you, Mr. Garrison. We have one more round, and I think I don't have the Conservative name, but if I could ask the clerk who would like to speak for the first 5 minutes.
Yes, I'm sorry. I have Mr. Caputo.
Maybe I do.
Sorry about
Mr.
that.
Caputo, sorry about that. For 5 minutes.
Thank you, Chair, and thank you, Minister, for being here. It's always a pleasure to have you here. I just want to pick up on your first statement that intoxication doesn't excuse sexual assault. And I think that that's something that around this table we would universally state. We really do have an epidemic on this issue, not only on education, but also on the occurrence and how frequently it happens. Now, this was picked up on by my colleague, Ms. Diab, and I just want to clarify. I took your statement as being a moral statement to saying, you just because you have had something to drink or a lot of drinks does not excuse the fact that you take someone's sexual dignity and that you don't have their consent to do this. Because really what we do have, and Bill C, or pardon me, Section 33.1 recognizes this, is that we do have an excuse in extreme intoxication. It may be rarely used, but it still does exist. Am I making sense when I say that?
It is possible only, and you would know this as a former prosecutor, it exists only in a very rare, particular set of circumstances. Because you have to establish, first of all, as the accused, according to the Davio test, that you were in a state of extreme intoxication. You have to do that with expert evidence. And only once you do that, then the Crown can, A, disprove that, and if they disprove it, your defense is done. Or they can then move to the point we're on today, which is go to the criminal negligence standard for how you entered into that state. And so only a very rare set of circumstances would put you there. The court has said, jurisprudence has said, we have said around this table, that intoxication is not a defense to crimes like sexual assault. I can say this to you again as a former prosecutor. It's a general intent defense.
Yes.
So it's not going to be a defense, and we need to make that clear.
Yes. No, I do take your point, because on a basic level, I don't understand. And this is just on a human level, not on a level as a lawyer, how somebody can be in a state of extreme intoxication akin to automatism, as in you don't know what you're doing, where you're going, what you're saying, and still commit a sexual assault. On a basic human level, I just don't understand how that is the case.
And just to reinforce that, if it's alcohol, probably impossible for you to get to that state and still be functioning,
Yes.
right? So, but the point here is some kinds of drugs, and we're working out those standards. But again, the standard example that I use is the prescription drug that you take because the doctor tells you to take it, that there's no way you could have known that this would have happened. If there are potentially known side effects, and you knew about it, that probably negates your defense.
The reason I used intoxication by alcohol is, as I recall, that was Davio. That was the facts. Now, for me personally, this is an area of significant concern. That's why 2 weeks ago I put forward Bill C-299 that would raise the maximum sentences for all sexual offenses, or not all, but almost all sexual offenses proceeding by indictment to life imprisonment, to reflect this epidemic and to reflect the seriousness of this, that victims themselves are often put into a psychological life imprisonment when they are sexually assaulted. Is that something you can see yourself supporting?
I'm happy to take a look at it. As you know, my problem was with minimum mandatories. We have raised maximum penalties in other areas, and I will undertake to look at it with an open mind.
Thank you all. Well, perhaps we can chat at a future date. Now, one of the issues we have with new legislation, and you'll be aware of this, is that we have 10 provinces, 3 territories, and this law will be tested in every single one of those. So it gets tested at the trial level, then it goes to the Court of Appeal, then it has to go to the Supreme Court of Canada. This costs probably hundreds of millions of dollars in litigation. There's one way around this, and that's with a reference case to the Supreme Court of Canada, who could say the revised Section 33.1 is, in our view, constitutional or unconstitutional. Was there any thought given to that? Because one of the things that we're hearing about in consultations, in my view, and one of the things we're talking about today is uncertainty. A reference case would give us certainty. So my question is, was there any thought given to a reference case to the Supreme Court of Canada?
In this particular case, I'll be honest, no, because the court gave us such a clear roadmap. A or B, we took B, and also because there are so few cases that invoke this particular defense over 20 years, less than 10 if I'm not correct, if I am correct, and so I think it is highly unlikely we're going to see the successful invocation of this defense, except in the most extreme in the most rare, I don't want to say extreme, in the most rare of circumstances.
Thank you, Mr. Caputo. And last, we'll have Ms. Briard for 5 minutes.
Merci, Monsieur le Président. Merci, Monsieur.
Thank you. And thank you to the Minister for being here. We've just completed our study on the Canadian Charter on the Rights of Victims. Do you think that this new Section 33.1 strikes a correct balance between the rights of the accused and the protection of the victim? Thank you. Yes. Yes, as I've just said, in response to Mr. Fortin, we are broadening as much as possible the field so that we are able to find someone guilty. That is to say, someone that is intoxicated. I believe so. Of course, we have to do other things as well for victims, but in the legal sense, I believe so. Thank you. Also, this new section 33.3 foresees that to decide if a person was far from the standard, the court will be able to take into account some circumstances, relevant circumstances, for example, what this person did or didn't do to avoid risk. What are they alluding to here? Do you think that this would allow the courts to take into account the situation of individuals? For example, if an accused is part of a marginalized group, a group that is being targeted disproportionately, or indigenous or racialized people. So the short answer is yes. This is a contextual analysis that has to be conducted depending on the circumstances, with an objective standard. So it's an objective standard. Criminal responsibility is an objective standard. Factors, the substances, the state of mind of the individual, the nature, and the quantity of the substance consumed, measures taken to minimize risk. All of these are possible factors, but we leave it up to the courts to determine if, according to the objective standard, if the person has reached the threshold. This has worked well in the past, and especially in very rare cases where it might be possible, I think that the courts will do their work. Thank you. So in practice, what will this require of police officers that would have been present, of the prosecutors? I don't really mean the weight of evidence, but what is going to be added? This is an obligation on behalf of the accused to present evidence with experts to show that they were in a case of extremely intoxication, and then the prosecutor must demonstrate that that was not the case, or that according to 33.1, there was a departure from the standard, and therefore the person cannot benefit from the defense. For prosecutors, these are known standards. These are standards with which they are used to working. They're used to working with these, and so it should work quite well. And for judges, they are also, after Davio and 33.1, they're used to working with this, and I think that for them it's very well known, and the specification that we've just added will help them. Thank you. In what other context of the criminal code is this standard being used, that is of criminal negligence, predictable criminal negligence? It's included in things, for example, dangerous driving, the omission of someone to provide necessary care for life, for young children, these types of things. So this is known and it is used. And I think that we're seeking to target the same type of infraction.
Thank you, Ms. Briard. I want to thank Minister Lametti for attending and generously staying a little longer as we had started slightly late. So we thank you, and I think his officials will continue. So I'll give him a minute to leave. And in the meantime, we will have Matthew Taylor, the General Counsel and Director of Criminal Law Policy Section, and Joanne Kleinberg, Senior Counsel Criminal Law Policy Section. I think Joanne is by video conference, and Chelsea Moore, Counsel Criminal Law Policy Section for the remaining hour. So thank you once again, Mr. Lametti, and we will now resume with the first 6-minute round with Mr. Caputo.
Thank you, Mr. Chair, and I'll just let our witnesses. Are you good to go here? Yeah. You think so? We'll be okay? All right. Thank you very much, Ms. Moore, Mr. Taylor, for being here. I'm going to resume, actually, where I had one more question for the minister, so I will direct it your way, and it is along the reference case. And I'm certainly not an expert in constitutional litigation, but my understanding, and correct me if I'm wrong, is that if somebody does want to challenge the legislation, it need not be based on the specific instance before the court. It could be on a reasonable hypothetical. Is that accord with your understanding as well? Yes. So the minister did speak about the fact that these types of, in his words, and I'm paraphrasing, they'll be quite rare. But a reasonable hypothetical doesn't necessarily have to come before the court with that rare case. It could simply be argued with that rare case. Do you get where I'm going with that? Okay. So this isn't an instance of us simply being in a situation wherein it's a rare case, so it's going to be a rare case that's litigated, and even more of a rare case that strikes it down. This is an instance where there could be a rare case to litigate it and put forward a reasonable hypothetical that's not before the court. Would that not suggest that perhaps we should be going to the Supreme Court of Canada on a reference case to let's ensure we get this right? And I obviously voted for the legislation, so you know where I stand. But I just want to have the tightest legislation possible. If you could comment on that, please, I would appreciate it.
Sure. I mean, I think Minister Lametti's already kind of spoken to the thought process that he took in terms of the decision to introduce the bill, the decision not to put a reference to the court. As he said, we did have a bit of a roadmap from the Supreme Court, from the Brown decision. Certainly that informed the work that the department did to support the government introducing the legislation. The charter considerations are detailed in the charter statement. As you know, the law that was passed in C-28 is quite informed by the law that came before it. And perhaps the last thing I could say, and my colleagues could jump in, would be the criminal negligence standard is a well understood and accepted minimum fault requirement for criminal law, and that's based on Supreme Court guidance as well. So I think all of those things taken together provides a context as to why the route was taken as it was.
Thank you. And I'm sorry, I neglected to recognize our witness by video as well. Is that correct? I apologize for that. I'm looking at the screen here. I do apologize for that. Well, you spoke about the roadmap, and as my colleague Mr. Garrison pointed out, there were two paths, and we took one path. And again, I voted for the legislation, but I would be remiss if I didn't ask this question, just to ask, because it has to be asked. I'm looking at paragraph 98 of the Brown decision. And I'm going to quote it here. It may be that the voluntariness problem could be avoided if Parliament legislated an offence of dangerous intoxication or intoxication causing harm that incorporates voluntary intoxication as an essential element, in this hypothetical offense. The gravamen of the offense is the voluntary intoxication, not the voluntary conduct that follows. And then later in the paragraph, this, however, is not what Parliament enacted in Section 33.1, in that Section 33.1 exposes the accused to jeopardy for the underlying offence, not the extreme intoxication, which is not in itself an unlawful act, end quote. So what I'm seeing there is almost an invitation from the court to go down that path. Now, I am mindful, like all of us, of parliamentary sovereignty, in that we dictate our own journey, if you will. And I'm also mindful of the minister's comments that you would have to charge 2 offences instead of 1. You'd have to charge sexual assaults, and then you'd have to charge criminal negligence caused by extreme intoxication, to wit, sexual assault. Was there a concern that perhaps the court was sending us in that direction? Is there any concern that maybe the court was saying, look, this is the most airtight way to do it? I invite your comments on that.
Thank you for the question. So as you mentioned, there was 2 choices that were provided by the Supreme Court of Canada, and Parliament made a decision about the choice to take. So the thing with the standalone offence, the option that you just talked about, it would actually be something like a standalone offence for dangerous intoxication, for example. So the thing with that is that the person would not actually be convicted of the underlying offence of violence, like sexual assault or assault. They would instead be convicted of dangerous intoxication. There have been concerns when this issue was raised back in when the initial provision was drafted in 1995. There were concerns expressed that this would sort of be like a drunkenness discount because the person might not have the same stigma or the same range of sentencing that they would get if they were charged with the underlying offense of sexual assault. The other issue with the standalone offense is that only the accused is going to have possession of the evidence that goes to their intoxication. So the substances that they consumed, the accused is going to have that evidence. And so it would be very difficult for the Crown to prove dangerous intoxication because the Crown wouldn't necessarily have possession of that evidence.
I believe we're out of time. I don't mean to cut you off. Thank you
you
for that clarification. I really appreciate your time. Thank you.
Thank you, Mr. Caputo. Now we have Ms. Dillon for 6 minutes.
I'll continue with Ms. Moore. As my colleague, you were explaining that it's only the defendant who would have the evidence as opposed to the prosecutor. So I was wondering if you could explain to us what this evidence would consist of. Would it be blood tests and other indications that there was extreme intoxication?
So it could be evidence of blood tests that they have. That's unlikely that an accused would have that type of evidence. It would likely be in the sense of testimony that the accused provides about what they consume. There could be other witnesses who might testify as to the state that the person was in at the time. But the reason why we have the accused that must prove the defense on a balance of probabilities and and with expert evidence is because the accused will be in possession of that type of evidence. And so that's why the common law rule sets out that the accused must first prove that they were in that state before the court will accept the defense.
Very similar to an alibi defense where it's up to the accused to prove that there was a mitigating factor.
Yeah, for the defense of extreme intoxication, there's it's the accused's burden to prove that they were in that state.
Okay, and can you explain to us, because I've heard during testimony the words, and this is as in the same vein that our colleague Ms. Diab spoke about in lay people language, the difference between intoxication, extreme intoxication, and I'm hearing the word dangerous intoxication being interchanged. Is there a different level to all three?
So I was using the term dangerous intoxication to refer to the approach that was suggested by the Supreme Court, one of the 2 approaches, that there could be a standalone offense. But there are some rules in the common law about the different degrees of intoxication, and those were established in the 2007, I believe, decision of Daly. It's a Supreme Court of Canada decision, and they go over the 3 degrees of intoxication in the criminal law. So there's mild intoxication, which is never a defense to any crime in Canada. There's advanced intoxication, which could be a defense to specific intent crimes like murder. And then there's extreme intoxication, which can be a defense to crimes of general intent, violent offenses such as sexual assault or assault. So those are the 3 types of intoxication, sort of degrees of intoxication that we have in the common law. It's important to note that even advanced intoxication, where someone is very inebriated, they can't tie their shoes, they have difficulty driving, that type of intoxication would not be a defense to the vast majority of violent offenses in the criminal code that are general intent offenses.
So as the minister mentioned before, it's very rare that this defense, even when invoked, is rarely successful.
That is correct. Given the significant evidentiary burden that's placed on the accused, they need to call expert evidence, but also the test that they need to meet. So they need to prove on a balance of probabilities, which in other words means that they were more likely than not in a state of extreme intoxication at the time that the violence was committed. They need to prove that on a balance of probabilities, which is the most rigorous test that we have for raising a defense in the criminal law. It is considered to be quite an onerous test to meet, and in that case, it could be rarely successful. The other thing is that the former provision 33.1 effectively prevented the defense from being successfully used since it was enacted in 2005. So we don't have a lot of data with respect to the defense over the last 20 years or so.
And this is the R versus Brown case where the Supreme Court spoke about the 2 different options. Can you please state to us the advantages and disadvantages we would see?
Apologies, the advantages and disadvantages
of the creation of the offense of dangerous intoxication or intoxication causing harm.
So I can't speak to the merits of the policy option that was taken necessarily. As I mentioned, the standalone offense option wouldn't necessarily allow for the same sentencing ranges or the same level of stigma that the option proposed, the option that actually was enacted in 33.1 would have. I think that's about all I'm going to say on that. Thank you.
Okay, thank you. And maybe for all of our witnesses, if you could cite a concrete example of when this defense was successful, in what conditions maybe the person was found in, as opposed to when it was not successful at all. Just a concrete example of what...
So, to our knowledge, it has not been successfully invoked since Section 33.1 was originally enacted in 1995. It's been raised in many occasions, but it hasn't been successfully invoked. There was approximately 12 to 15 cases which considered the constitutionality of the provision leading up to Brown and Sullivan and Chan. And in those cases, I think 6 or 7 of them struck down the provision and allowed the defense to be pursued. But in all of those cases, the defense was rejected on the merits. So we don't have, since the original provision was enacted in 1995, we don't have a case up until Brown and Sullivan and Chan where the defense was successfully used.
And
thank you.
Oh, thank you.
Thank you, Ms. Dillon. Next, we have Monsieur Fortin for 6 minutes.
Merci, monsieur.
Thank you, Mr. Chair. I'm going to continue. Mrs. David stole my question, really, that I was wondering. It's a little bit paradoxical, don't you think, to believe that someone will voluntarily place themselves in a situation of such an extreme level of intoxication that, as the minister was saying, it is extremely, extremely rare. How can one voluntarily place oneself in this situation, commit a crime, and then say that they cannot be found guilty because they did not voluntarily place themselves in a situation of extreme intoxication? When it's involuntary, I can understand. As I was saying earlier, I can understand if someone drugs my drink, 7-Up or whatever it is, okay, that's one thing. But if we say it's voluntary, this means that the individual became intoxicated voluntarily. So it's not someone who drank 5 glasses of wine and then they're over the legal limit for driving. That's not what we're talking about here. We're talking about someone in an extreme state of intoxication and that voluntarily placed themselves in this situation. Do you have any examples? It's really hard for me to imagine a case where someone could use this successfully. Unsuccessfully, okay, but how could you evoke successfully such a defense? Thank you for the question. I think that I'll ask my colleague, Joanne Kleinberg, to answer the question. Hello? Can you hear me? Yes, Mrs. Kleinberg. It is a bit of a paradox. I'm going to speak of the current act after the entering into Act of 33.1. It is a bit paradoxical because you have the accused that has to prove that they were in a state of in an automatic state, but that it was not predictable or foreseeable that they could find themselves in this state. So, according to what we're understanding of the Brown decision from the Supreme Court, the circumstances where one could today, after 33.1 becoming law, you could have a statement of not guilty, and that the defense might succeed, and that there is no proof of negligence. It might be a circumstance where, for example, you have a state where the person is not controlling their actions, and this was not recognized as being possible for the reasonable person. So this is the case where you would have a consequence on the mental state that was not predicted and not that one could not have predicted from a reasonable point of view. So these circumstances led the Supreme Court to find that there was a violation of rights according to the Charter. So it is possible, but it is so improbable that a reasonable person would not see this as a risk. It's very improbable in circumstances that these types of circumstances could arise. It's theoretically possible. Thank you. So theoretically possible, I understand, but I'm looking on a practical level what can happen. I cannot imagine a situation such as this. I'm wondering if we're not working on something that is virtual, that is interesting for law professors and universities, but people working in the field, it would be impossible. So I know that you don't have any examples to give me of any situation where you could have invoked this type of defense of voluntary, or rather self-induced extreme intoxication. There are no known cases. Well, it depends on the facts of the case, the evidence and the quality of evidence. So it's difficult to imagine what would be a verdict or how a trial will happen. If one piece of evidence is changed, the verdict could change. So this is a calculation that has to be done in a specific case on the evidence presented and with a legal analysis of the quality of the evidence, we think that it will be extremely rare that someone would be able to prove that they were in a state of self-induced extreme intoxication, that the risk of perhaps committing a violent act, if you have people around you, that this is something that the Crown will not be able to lay out. Thank you. In a few seconds.
Next to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I did have a question about the data on the number of cases. I think you've really answered that, but I just want to make sure that I understood that correctly. That in all the time that 33-1 was in case, there were only about 12 to 15 cases which raised the constitutionality of the section, and none of those were successful until the most recent 3 cases. Is that correct?
To the best of our knowledge, yes.
And the minister said since this has been passed, there have been no cases before the court. Just to confirm that that's true?
Yes, that's correct. There have been no reported cases that have required the use of the new Section 33.1.
Great. Okay, thanks. I want to ask a question about the wording of this new provision, which says the court must consider, quote, all relevant circumstances, including anything the person did to avoid the risk. I guess I have 2 different questions about this section. But anything the person did to avoid the risk, are there any established legal standards for avoidance of risk that would apply?
So since this legislation has not yet been tested and negligence cases tend to be very fact-specific, what a court considers to be relevant in terms of the steps that the accused took will really vary depending on the circumstances. Courts may look at things like the state of mind of the accused at the time. In terms of steps, they might expect that a person who's about to consume intoxicants would want to know what the potential effects of those intoxicants are and would want to learn about those effects and learn how they can be more careful when they take intoxicants. A court could expect a person to remove their weapons if they're going to take intoxicants. They could expect them to want to isolate themselves from other people or to ask a sober person to supervise them, for example. These are the kinds of things that we might expect courts to look at here.
And my second question of this is probably considered even more rare, but when all relevant circumstances, how would that interplay with the Gladue principles? In other words, Gladue principles require judges to consider relevant circumstances. Will that come into play then with this offense?
Maybe I'll start if I understand the question. I think Ms. Moore might have already spoke to it, or Minister Lametti. The assessment of whether the individual acted in a criminally negligent way won't be personalized. So it's not simply a question of their unique circumstances. So I think the answer is it doesn't intersect, but perhaps I've not understood correctly.
Well, you've understood that's the answer I was hoping for. Again, I accept that what we've done here is chart some new ground, and so given the rarity of the cases, it may be quite a long time before we can answer a lot of these kinds of questions. So, Mr. Chair, I have no further questions for the witnesses. Thank you.
Mr. Garrison. Next, we will go to Mr. Van Popta for 5 minutes.
Good. Thank you, Chair. Thank you to the witnesses for being here. We're talking about the defense of extreme intoxication and when and under what circumstances it is available for an accused person. The minister in his earlier testimony today clarified that in order for this defense to be available for an accused person, he would first have to prove using expert evidence that he indeed was in a state of extreme intoxication. And Mr. Lametti colloquially defined that as his body is functioning, but he's not in control of it. So I think that's useful everyday language. But my understanding is that once he has proven that to the satisfaction of the judge or the jury, that the burden of proof then shifts to the Crown to prove that he acted negligently. Now, we have a comment from Professor Kerry Frock of the University of New Brunswick, who, discussing that, recognizes the, quote, problematic aspects of the bill, which we fear will pose nearly impossible hurdles for the prosecution of intoxicated perpetrators of violence against women. So, and then she goes on to suggest that maybe Section 33.1 could be further revised to reverse the onus, to leave it up to the accused to prove that he had not acted unreasonably, just because it's so difficult for the Crown to prove and easier for the accused to defend against that. So what do you say about that? Seems like a reasonable option.
Thanks. So I can't speak to the specific merits of that policy approach, but I can provide some legal considerations to think about when it comes to the burden of proof. So to start, in the criminal law, for the most part, it's the Crown that needs to prove all the elements of the offense beyond a reasonable doubt. And any reasonable doubt must result in the acquittal of the accused. So that was first recognized in the 1935 House of Lords decision in Wilmington. And it's also known as the presumption of innocence, which was incorporated into the Canadian Charter in 1992. And so the jurisprudence on the presumption of innocence has been pretty straightforward in the sense that anytime a person may be convicted without a reasonable doubt, courts would likely find there to be a violation of the presumption of innocence that would then need to be justified under Section 1 of the Charter. And something that you might want to think about is the reason why we have this reversal of the burden with respect to the accused raising the defense of extreme intoxication is because in those cases, similar to mental disorder or non-mental disorder automatism, like when you commit a offense while sleepwalking or having a seizure, you're dealing with the internal impairment of the accused, and the Supreme Court, an internal mental impairment. And the Supreme Court indicated that in those types of cases, it would be very difficult for the Crown to prove the internal mental impairment of the brain of the accused, and the Supreme Court justified having the reversal of the burden in those cases, requiring the accused to prove on a balance of probabilities that they were in that state. And so there's special considerations for when such a type of a reversal of a burden of proof could be justified under Section 1 of the Charter. Those are some considerations you might want to think about.
Right, and those are very important considerations. And I appreciate the complexity of that and how Section 1 of the Charter operates. But yet here we have a professor of law saying that the burden on the Crown is almost impossible. And for example, if we were to take R versus Brown, the Crown might have advanced pretty compelling evidence that Brown ought to have known what the effect of consuming vast amounts of alcohol and combining that with magic mushrooms might do. But then Mr. Brown, and it would have to prove that on a balance of probability, beyond a reasonable doubt. But then Mr. Brown, on a balance of probabilities, would only have to prove that he was not acting unreasonably. Maybe he had never consumed magic mushrooms before, for example. So he could not have known what the effect would be. And Mr. Brown would walk a free man. It seems unreasonable to common people, non-lawyers. Do you have a comment about that?
Well, just that, so the provision, so as the minister mentioned in his opening remarks, the level of risk doesn't need to be probable or even more likely than not. It's whether it's not whether an accused should have known that the drug would lead to a violent loss of control, but whether the accused should have known that the drug could lead to a violent loss of control. And the court's going to look at this from the perspective of a reasonable person. And what is a reasonable person is not someone that's going to come and testify what they knew or what they did. It's going to be assessed on a case-by-case basis. But the reasonable person is a concept that's well known to the criminal courts. It's someone who's prudent, who thinks before they act, and who takes steps to prevent harm when they see it happening. Courts are going to make a determination about the reasonable person by drawing inferences from the available facts and the evidence. And so the fact that I'll stop there. Thank you.
Sorry about that. I gave you a little bit of time. Thank you, Mr. Van Popta. Now, Ms. Briard for 5 minutes.
Merci beaucoup, Monsieur le.
Thank you, Mr. Chair. Could you explain to us what were the motives to declare unconstitutional the first version of 33.1 in terms of actus reus, mens rea, and presumption of innocence? And secondly, how is it that this new version, how does it fill in the gaps? Thank you. I'm going to ask my colleague, Mrs. Kleinberg, to answer. Thank you for the question. What the Supreme Court said with regards to the former version of 33.1 is that the former version presumed that negligence existed when the person was consuming the intoxicant, but without it being proved by the Crown. The former version allowed a statement of culpability for a person who was found in a state of, in an automatic state, but without being able to have expect that it would be possible that they would be in this state. While they are in this state, they commit a violent act towards another person, and because of 33.1, the former version, the point of this was to have a guilty verdict for sexual assault, for involuntary homicide, or manslaughter, but if you have a person who did not have the mental, is not in a mental state to commit an act, or they could not control what they were doing, for example, they could be found guilty for a violent act that was outside of their control. And that is the reason, the main reason, why it was found that human rights were being violated. The new version of 33.1 remedies the situation because it defines the elements of these infractions: sexual assault, manslaughter. There's a new definition for these charges based on the consumption of the intoxicant, negligent consumption, where they risk being in a state of loss of control and where there's a risk of violence. The Crown needs to prove negligence with regards to consumption, then this creates the danger or the risk of violence. And this is an essential element now. If it is proved by the Crown that there was the person is able to be found guilty for violence because of their negligence during the period when they consumed the intoxicant. Thank you. And so when you were saying that negligence has to be proved, the negligence linked to the consumption of the intoxicant, what are the data or what's the science behind the quantity that has to be consumed or the drugs that have to be taken to reach this threshold of extreme intoxication? Science is ever evolving, and it also depends on the nature of the substance that was ingested. It depends on many different things. The impact that the act of consuming an intoxicant can have on a person, it's a very complicated issue. The mental state of the person while they're consuming the intoxicant, the type of intoxicant, there's a lot of documents and a lot of knowledge among the public of how to avoid high levels of intoxication. Yes, but here we're talking about voluntary intoxication.
Thank you.
Last, we will now have Monsieur Fortin for 2.5 minutes.
Thank you, Mr. Chair. And I'm going to add to what my colleague, Mrs. Bruyère, was saying. The situation seems so rare that we are not even provided with examples where a person could present this type of defense successfully, to the point where I'm wondering, aren't you worried that it would be so difficult to evoke this defense that the Supreme Court would say once again, listen, it's not workable. The difficulty in imagining a situation doesn't not make it so that the section could be in violation of the Charter. I'll ask Mrs. Kleinberg to answer. I don't think I really understood your question. I'm sorry. Could you repeat it? Yes? What I was saying is that the difficulty that we're having in providing examples here, we're all here, and I consider you as being subject matter experts. There are many jurists around the table as well, and no one has been able to provide an example to say, oh yes, this defense could be evoked in such and such a situation, to the extent where I'm wondering, there's a principle of interpretation. We say that legislators shouldn't speak to say nothing, and so the acts that we adopt should have a useful end. Are we not placing ourselves in a situation where we might be told the 33.1 could be invalidated by saying it's totally impossible to use this defense in any case. So the section has no legal value and should be considered as being a non-starter. Is there not a fear of that? I think I understand now. I hope I understand the question in any case. Well, I hope so too. Well, we could say that the Supreme Court in Brown, a couple of months ago, the court was confident that there could be circumstances where a person might be able to demonstrate that they were in an automatic state, but that they were not able to predict that they might find themselves in this state. So the Supreme Court thinks that it's possible. And I would also say that 33.1, it doesn't create a means of defense. It doesn't define the means of defense, nor the process. So 33.1 doesn't directly affect the availability of means of defense. It does create a rule for penal law. It defines the elements of guilt, and then the question is to see if the elements of guilt in 33.1 are constitutional or not. And as the minister was saying, the Supreme Court suggested this option as being constitutional. Thank you.
I want to thank all the witnesses for your great testimony today and helping us understand Bill C-28. So we thank you for that. I just have some members' work to do, some housekeeping. The witnesses are dismissed. You're more than welcome to stay and listen to this, but you are free to go. Just want to give an agenda for the coming few meetings. Witnesses for Thursday, October 27th. The first hour we have Professors Elizabeth Sheehy and Carrie Frock and Isabel Grant. Second hour so far is Suzanne Zakour. Witnesses for Monday, October 31st, we have Action Now Atlantique and Hugues Perrant. And then the second hour, we have Women's Legal Education Fund and Action Fund and Farah Khan. So far, we're 3 witnesses that have declined our invitation has been the Canadian Bar Association, the Barreau de Quebec, and Robin Parker. I also want to let you know that the Manitoba Prosecution Service would like to be a witness for this, although they were not invited. So I will ask if we have consensus to invite them. Unless I hear otherwise, I will invite them and have them appear either then or November 3rd. I think we have a slot on November 3rd. Hearing no objections, I will invite them. So that leaves us for our November 3rd meeting, which should be a 2-hour meeting with this additional witness. And then after that, we'll get drafting instructions from our analysts on that. Mr. Clerk, is there anything I've missed?
Mr. Chair, there might be some other suggestions for November 3rd.
Sure. Any members, Mr. Nansangari or Mr. Moore?
So since we're not filling all the slots, I'm wondering maybe the analyst could give us a sense of by party distribution how many witnesses we can add on, just to have a full 2-hour panel on the 3rd. Or Mr. Clark, sorry.
Sure. Yes, it would be good since if we're going to November 3rd with a full 2-hour meeting, it would be good to have 5 or 6 more witnesses in terms of giving us room if any decline or whatnot. So 5 or 6 would be good. Yes.
Okay, and then how do
Mr. Clerk, can you kind of distribute it amongst parties? How many, is there any party that has not given their full roster, or how many each of one of us should give? I think that's what Mr. Nansangari is trying to get.
Do you mean so far who have confirmed, or for November 3rd?
So basically, based on who's confirmed and those who've declined, if there is a party, like maybe you can send it to us this afternoon, just a breakdown of if we're giving you 6 names, then it should be to Liberal, to Conservatives, or what have you, right? So if you can maybe break that down for us, and then maybe have the names to you by end of day Wednesday, by 5 o'clock on Wednesday.
Okay. Yes, I can do that.
Anything else that I might have missed, or anybody in the room that wishing to speak? Mr. Clerk, if you can have a look. No? We're good? Okay, well, thank you, gentlemen and ladies and gentlemen, and we'll, Ms. Diab, was that a bye or was that a, okay, thank you. We'll see you on Thursday. Thank you. Meeting is now adjourned.
you.